Good morning, Your Honor. Amy Riser on behalf of the people.
James Thomas on behalf of Mr. Radcliff.
I don't know, Johnny, on behalf of Mr. Radcliff.
All right. The record should reflect we had an in-chambers conference in this matter, and there were certain issues I think that the parties wanted to raise. So we'll start with the people, Ms. Riser.
Thank you, Your Honor. I emailed counsel and your staff last week indicating that I would be making a motion under statute to close the courtroom for 4 of the victims. And I will only state their first names: Weston, Isaiah, Noah, and Maxwell. Isaiah is 17 years old. Noah is 18. Maxwell is 18. And Weston is 18. Isaiah, Noah, and Maxwell are still in high school. And we're making a motion to close the courtroom. The statute that governs that is MCL 600.21663A. If upon the motion of a party made before the preliminary examination, the court finds on the record that the special arrangements specified in subsection 17 are necessary to protect the welfare of the witness, the court must order those special arrangements. In determining whether it is necessary to protect the welfare of the witness, the court must consider all of the following: the age of the witness, and I would indicate that these are still very young witnesses, the nature of the offense, child sexual abusive activity, the desire of the witness or the witness's family or guardian to have the testimony taken in a room closed to the public. And all of the parents and the grandparent guardian of Weston are asking that the courtroom be closed for their son's testimony. And the physical.
I'm sorry. All of the parents
of the victims that I listed: Maxwell,
Gotcha.
Noah, Isaiah, and Weston. All of their parents are requesting that the courtroom be closed, and the physical condition of the witness. These 3 of them are still in high school. So there has been a lot of media attention. All of these individuals went to church together. I know that the court previously pulled some letters of support out of the public court file for safety reasons. I've indicated to the court and counsel there are 2 victims who are not appearing today because of safety reasons. So I will not be able to proceed with the assaults against them. And I think for the privacy of these minors, that the courtroom should be closed for them. And subsection 17 indicates if the court determines on the record that it is necessary to protect the welfare of the witness and grants a motion made under subsection 16, the court must order both of the following: that all persons not necessary to the proceeding must be excluded during the witness's testimony from the courtroom where the preliminary examination is held. Upon request by any person and the payment of the appropriate fees, they can obtain a transcript of that witness's testimony at a later date. The courtroom be arranged so that the defendant is seated as far from the witness stand as is reasonable and not directly in front of the witness stand in order to protect the witness from directly viewing the defendant. The defendant's position must be located so as to allow the defendant to hear and see the witness and be able to communicate with his or her attorney. So we're asking for those 4 witnesses, Weston, Isaiah, Noah, and Maxwell, that the courtroom be closed, and particularly for Maxwell, Noah, and Isaiah, who are all students still in high school. And I did send some case law to the court and to counsel last week, People versus Dontavius Anthony Bell, 219 Westlaw 473-2615, where the courtroom was closed for a 15-year-old criminal sexual conduct victim in that case.
just so that I'm also clear, the statute also would require that if I do close the courtroom, the testimony is not closed, but the court also has to provide some type of system or some viewing for the press and for others who are excluded from the courtroom to view the proceedings still.
So the other, the case law does talk about the right to an open trial is absolute, and that's People versus Klein. this party seeking to close the hearing must advance an overriding interest that is likely to be prejudiced. And the closure must be no broader than is necessary to protect that interest. The trial court must consider reasonable alternatives to closing the proceeding, and it must make findings adequate to support that closure. So the court, the case law does contemplate a partial closure where the courtroom is closed and there would be a live feed to a different location. So it's technically still open, but the courtroom is closed for that witness's protection. We're asking for a complete closure for the 3 high school students.
Even to the press.
Yes.
That would be, you would admit, extreme. That they, I mean, as I'm understanding your argument, it's the witness testifying and the ability of the witness and emotionally otherwise to testify as opposed to anything else. Am I incorrect on that?
So with the high school student, Your Honor, the argument is twofold. It's the privacy of the student, the intimidation from the defendant's family, but it's also, if it is a live feed to a different location, the court can have certain orders, but these kids are still in school. And something gets on social media that they were a victim in a case, that's just difficult, quite frankly, for them to have to deal with. So I'm asking it for their privacy that it's completely closed. So they can testify without the press hearing it, without the defendant's family. The crime victims' rights statute allows them to have one support person with them in the courtroom. But for the 3 of them that are still in high school, their fellow classmates and I think their teachers and administrators know that they've been a victim at the hands of the defendant, but they're trying to finish high school, and it's a hard thing for them to have to do. For the other witnesses, for Weston, he's not in high school, but was very, very involved in the church. So maybe a partial closure for him. So where the press and the defendant's family could view it in a different room. And I believe all of the other victims are now in their 20s. And so I've had conversations with them that they will have to testify in front of people. And it would be aired, as you indicated, on YouTube, but their face would not be shown, and we would only be using their
Well,
first.
and that would be the case with, if I wasn't clear at the back, that's the case with all of the alleged victims testifying.
Correct.
I am excluding from video the witness box. So I am doing that with all of the witnesses, except for any police witnesses, but all of the alleged victim witnesses. So, well, it just seems to me, though, counsel, that the Weston is less clear, and I think even in your argument, you're making that clear. And then the Maxwell and Noah, if you will, in sort of that middle gray area. But I have some grave concerns about excluding, as I read the case law, the court really should provide a mechanism for individuals to use closed circuit to view the proceedings, because really this is about the emotional welfare of the individual. But okay, all right.
Thank you.
Attorney for Radcliff, any response to the motion?
Judge, we're not going to take a position on that.
All right. So with reference to the people's closure, and so they can get it all out of the way, anyone not necessary for any of the testimony of the witnesses will be excluded from the courtroom for the testimony of Isaiah. I am also going to do a closure for the testimony of Noah and Maxwell. Now, the court's basis for doing that relates partially to the testimony. Some of what counsel has indicated regarding other steps that this court has had to take to attempt to try to ensure the safety of individuals within basically the Augusta and Saline communities, well, really that southern tier of Washtenaw County. The court has had to go to the extreme step for supporters of the defendant to try to secure their personal identifying information from the public in terms of sealing. I hate using the word sealing, but certainly placing in a confidential part of the record those individuals and their names, addresses, and other information. I believe that the same, this court's perspective, applies to certainly Noah and Maxwell. The court is very cleanly aware that they are and have been notified that they are high school students trying to, I believe, finish up high school. As the people have pointed out, this has raised some publicity and other things. I think that their welfare would, in terms of testifying in open court, it should be, the court will close the courtroom in great part for the reasons as stated by the people. With respect to an alternative, whether you want to call it a partial closure, plea closure, as to the testimony of Noah and Maxwell, the court is going to provide a place where the press and others excluded can view that testimony. Regarding Isaiah, I am not and would not do that regarding the testimony of let me back up a second. I honestly do believe that and Mr. Reiser, please correct me if I'm wrong. I don't believe that I can close it completely. I don't think that anything has been shown to me that would lead to a complete closure regarding that testimony. And when I say a complete closure, I'm saying the courtroom being closed, but there being an alternative option to view the testimony.
You can, under the statute, order a complete closure if you determine it is necessary to protect the welfare of the witness. You consider the age of the witness, the nature of the offense, the desire of the witness's family or guardian to have the testimony taken in a room close to the public, the physical condition of the witness. And if you do determine that everyone has to leave they have to be excluded during the witness's testimony.
I will, and I would find that given the age of Isaiah and information has been provided regarding the nature of that witness during our bench conference, I will do a complete closure as it regards Isaiah.
Okay.
With regard to Noah and Maxwell, that will in essence be a partial closure. They will be able to testify. We'll close the courtroom. However, the press and others that are excluded can view that testimony. All right. So that will be the order of the court. I am also going to order that during the course of this preliminary examination, and I spoke with counsel about this, any of the alleged victims will only be referred to as an additional step in this court part by their first name. The court record will contain the actual name, full name of the individual testifying, but they are only to be addressed by their first names. All of the 13, I believe, witnesses that were listed by the people the court had checked and all have unique, I hate using that word, have different first names so that we're not going to run into any confusion. And I think we can certainly keep that clear. In that regard, I would also indicate, Ms. Reiser, just in terms for logistical reasons, that the witnesses and their family are in our jury assembly at this point. That is the place where we would normally be sending something. So hold on one second. You know what?
2 months may not sound like much, but in eviction court, that's a ticking time bomb. Let's put this into perspective. 2 months behind on rent means nearly $3,000 owed. And for most working families, that's not money you can just pull out of thin air. The landlord is losing income, the tenant is drowning in debt, and the court, it's stuck in the middle, deciding whether this household gets a second chance or a move-out order. This moment right here decides the direction of the case.
For the partial closure, could you do the another courtroom?
Okay. Mr. Reiser, you were gonna say something?
I was just, for the partial closure on Noah and Maxwell, I wondered if the victims and their families could stay in the jury room and the feed could go into courtroom B.
That's what we were just checking as to whether or not that can happen. And I think we may be able to do it either way. Usually it's the jury assembly room that we're sending things to. However, I think the mechanism by the technology that we're going to have to use to do that, we can actually do in courtroom B. So that once I close this courtroom, anybody that has been excluded from this courtroom for the testimony of those two can then go to courtroom B.
Okay.
If that makes it easier, I know they're already down there. I was going to say that I was going to move all of them to B and then go there, but why don't we give this a shot?
Okay. And then the families, obviously the other victims that have not testified would remain in the jury room with no feed, but the families that might otherwise be able to come in the courtroom and watch, would there be a second feed for them? The other parent? So if there are victims, family members who are not testifying and also want the opportunity to watch the testimony, is there somewhere we could put them separately so they would not have to be with the defendant's family? Or I might have, one second.
I think that what you're going to have to do is you're going to have to set that up, because I don't think that we'd be able to accomplish that with any great. If I use courtroom B to broadcast to those that are suing from the courtroom, they would then go next door. As I indicated to counsel, if I were then also to go to the jury assembly room, that room is able to be divided. However, those that maybe should not hear the testimony because I'm anticipating. a
Yeah, I don't want to
sequester,
feed in
I
because I'll have
can't
other
guarantee
victims in
that
there.
they can't hear
Right, if you close the wall.
if
Got
I
it.
did the wall.